All right, go watch the video on my page right before this one, where I talked about a new U.S. intelligence assessment. 17 of our 18 intelligence agencies under Trump and Tulsi Gabbard, 17 of them found no coordination between Venezuelan street gang Tren de Aragua and the Venezuelan government, contradicting statements that the Trump administration officials have made to justify their invocation of the Alien Enemies Act. Their own intelligence agencies are like, you didn't establish that. The other option is the United States has to be at war. Congress declares war. So we're not being invaded. We are not declared war. So they're saying it's improper that Donald Trump has invoked the Alien Enemies Act. And today we got a decision from a Judge Charlotte Sweeney in the for the District of Colorado, saying that there's no legal basis for Donald Trump for his invocation of the Alien Enemies Act. Judge says Trump can't invoke Alien Enemies Act. A federal judge ruled that President Trump's proclamation invoking the Alien Enemies Act exceeds the president's authority. The judge said the act refers to military actions indicative of an actual or impending war, not mass illegal migration or criminal gang activities. So, on March 14th, 2025, I'm reading from her decision, President Donald Trump signed a proclamation designating Tren de Aragua as a foreign terrorist organization and declaring, among other things, that Tren de Aragua is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. And that these proclamations, this proclamation's declarations were made pursuant to the president's authority. So, under the Alien Enemies Act, let me skip ahead to this section, we either have to be being invaded by the military of another government or at a state of war as declared by Congress. Neither of those things has happened. Trump's own intelligence services agencies are saying there's no invasion. The presence of some gang members from Tren de Aragua on U.S. soil, there's no evidence that they are being directed or are coordinating with the Venezuelan government. And Congress has not declared war. So, let me find this stuff here. This is a really good decision, and I had a really good time reading it. All right, so Trump invoked the Alien Enemies Act and had this proclamation about Tren de Aragua. And this is for two immigrant detainees being held in Colorado. Only their initials are used, and they filed for a restraining order against the government, and the judge gave it to them. So, according to petitioners, the two people who are trying to avoid being sent to CCOT prison in El Salvador, the proclamation that Trump made, it exceeds the president's statutory authority in three critical respects. First, there is no invasion or predatory incursion. Second, any purported invasion is not perpetuated by a foreign government or nation. And third, there is no process to contest whether an individual falls within the proclamation, because it's all muddy. And then the court goes through the definitions of those words, invasion, incursion, and invasion, predatory, and incursion, and was like, these mean coordinated military action. And the judge goes back through all kinds of U.S. history. The history of the law goes all the way back to when the law was written in 1798. It's a good decision. The court finds these definitions are persuasive in demonstrating what invasion does and does not mean. as a matter of plain language. Invasions contemplate military action. At a bare minimum, invasion means more than the proclamation's description of Tren de Aragua's infiltration, irregular warfare, and hostile actions against the United States. Definitions of predatory incursion likewise reveal a similar mismatch. Indeed, consistent with these definitions, the Supreme Court's discussion of the power to be exercised by the president, such as that conferred by the Alien Enemies Act, rests on the presumption that the United States is in a state of war. The life of the statute is defined by the existence of war. And we're not at war. So these words fundamentally demand military and wartime action. The proclamation makes no finding that satisfies these definitional demands. Trump's proclamation. There's nothing in Trump's proclamation that meets the definition of those words: invasion, predatory, incursion. Thus, to the extent the proclamation relies on the Alien Enemies Act's invasion and incursion provisions to justify its removal powers, it does so improperly. And then the court goes through some more history and concludes by saying that Donald Trump's proclamation, so the judge is saying the proclamation serves as the justification to invoke the Alien Enemies Act. And that's how Donald Trump intended that proclamation. But the judge found that the language in the proclamation does not satisfy the requirements to invoke the Alien Enemies Act per the statutory language within that act. And that his proclamation and invoking the Alien Enemies Act exceeds his presidential authority and is illegal. Yeah. So this decision came out of the United States District Court for the District of Colorado. Judge Charlotte N. Sweeney, Civil Action 1:25-CV-01163-CNS. Plaintiffs are DBU and RMM versus Donald Trump and Pam Bondi, Kristi Noem, and a whole bunch of other people. It's a fun decision to read. You should all check it out.